Hey everybody, it's Andy, and welcome again to my office in Los Altos, California. I'm an attorney licensed to practice law in California as well as New York, and in this video I'm going to go over the 5 questions that I think you should be prepared to answer if you're going to get involved in a breach of contract case. Now, specifically, I'm going to talk about California because that's where I am, but these questions I think are going to be general enough that even if you don't live in California, they are going to apply to you in one way or another. If it doesn't really kind of hurt you, like if it doesn't kind of tax you, I guess, go ahead and kind of come up with the answers to these questions, even though you don't live in California, because I think the principles, like I said, are general enough that they're going to help you organize your case. They're going to help you find a lawyer sooner, et cetera, et cetera. So anyway, I guess the concept of a contract probably is not going to really excite a lot of you. Contract lawyers sort of aside, I guess. But if you stop and think about it, actually, contracts actually underlie a lot of what daily life and kind of business kind of really involves. So, if, for instance, you're talking about a contract between 2 companies, where one company agrees to sell supplies to another, and it's worth tens or hundreds of millions of dollars. If it's a situation where you're buying stuff on credit, and there's a contract about how you're supposed to pay, when, how much, what the interest rate is, etc. That's really important. If it's stuff where you're renting something, an apartment, if you're renting a house, whatever, a variety of scenarios basically involve a contract of some kind. A variety of scenarios in the modern economy involve contracts of one kind or another. So the breach of contract situation actually arises more often than you would sort of immediately think just by hearing the word contract. So hopefully that kind of made sense as a sort of background. Breach of contract cases are actually quite common, is the point I'm trying to make. So I guess if all of that sort of made sense, let's go ahead and get started. So the first question that I would want to know the answer to if I was interviewing a prospective client basically would be, is this agreement that we're talking about, is this agreement oral or written? And I think the reason for wanting to know the answer to that should hopefully be obvious. A oral agreement that's just spoken between 2 people obviously is going to be a lot harder to prove. You might have witnesses, but the other guy to the contract might have witnesses, and maybe the witnesses contradict each other. You might have recordings, but the recordings could be subject to attack also. A written document that is clear, ideally. If it's clear, specific, if it's signed by the parties and dated and so forth, that's going to be a lot more clear than a he said, she said, for instance, about what this oral agreement supposedly was. And if you're talking about a written agreement, I actually have a separate video on my channel about the statute of frauds in California. I'm going to link that down below just in case you're interested. So anyway, the basic idea for question number 1 is this oral or is this written? What kind of agreement is this? Number 2, I've sort of alluded to already, and that basically is, depending on how you answer question number 1, oral or written, I guess, where is this document? If it's a written agreement, do you have the document? Where is it? Do you have copies? Is it signed, dated, etc.? Where is this document that supposedly memorialized the agreement? And also, for instance, does it comply with the statute of frauds, for instance? Number 2, or I guess the second way to answer number 2 is, if this is an oral agreement situation, what proof do you have that there was an agreement at all? Do you have an audio recording? Do you have emails after the fact that were just sent as confirmation? Do you have witnesses? Do you have videotape? Whatever. Because an oral agreement is very hard to prove, what proof do you have of it? So that's basically question number 2. Do you have the written document, if this is a written agreement, or do you have proof that the oral agreement said this, actually existed, etc.? So that's number 2. Number 3 is perhaps a little bit esoteric, I guess, a little bit sort of technical. But number 3 basically is, have you as the prospective party, have you basically complied with everything you're supposed to do in this contract? Or was your performance excused in some way? So I guess not a lot of people know this, or not a lot of lawyers even know this, is that if you're trying to sue for breach of contract, you yourself have to basically show that you have done everything you're supposed to. You have performed under the contract, you've complied with it, the other guy has not, and therefore you're suing for that. A lot of people try to actually sue the other guy, for breach of contract, when it's actually quite obvious, quite evident that they have not complied with the contract either. So basically, in general, in order to sue for breach of contract, you have to show that you've complied, you've performed, you've done everything perfectly. The other guy is the jerk. The other guy is the one who's causing problems, etc. So depending on the contract, it is possible for you to actually prove that you've done everything. It's actually possible to, for you to do your part. In some situations, in some contracts, it's actually not. So the thing is, let's say, for instance, that in order for you to do your part, the other guy needs to do his part first, let's say. Or let's say that the contract was so vague that, you had no idea what to do. And you were trying to negotiate it or something. So in certain contracts, it is actually quite possible to show definitively that, yes, you have performed, you have complied, etc. In other situations, it might not be so easy to do that. And that's kind of where legal representation, I think, is going to be really helpful for you. So that's number 3. Have you, as the prospective client, prospective party here, have you done everything you're supposed to, or is your performance excused in some way? Number 4 is sort of related, I guess, to number 3. And number 4 basically is, what was the other guy supposed to do for you? If this contract had actually been performed properly, what was the other guy supposed to do? Was he supposed to sell you a bunch of components at a really good price? Was he supposed to, pay on a certain schedule? Was he supposed to, rent you this apartment, rent you this boat, whatever? To have a good idea of what the contract was supposed to kind of give you, I guess, that's actually really helpful to kind of define the case, to help you kind of compute what the damages are, etc. So hopefully, again, it depends on the contract, but hopefully it's actually really easy to kind of articulate or try to organize to determine what exactly this contract was supposed to do for you. So that's number 4. What exactly were you supposed to get? What was the other guy supposed to do for you, basically under this contract? Number 5. Number 5 basically is going to be what your damages are under this agreement. So, if there was a written contract and the other guy breached it, how much damage did that do for you? Like, what money would make it so that you are basically in the same position you would have been in had this contract actually been performed? So this gets into a little bit more of a discussion, I guess, because when you talk about contract damages, there's actually several kinds. So one term which you might kind of see or hear, if you Google it enough, I guess, is expectation damages. So that's something where if you were, if you had a contract that was supposed to give you a really good price on, say, 1 million widgets or something, and that contract was breached, then your damages hopefully would be, okay, whatever the difference in price that you had to pay was multiplied by the 1 million widgets. You might hear another term called consequential damages. Those are not real they're not hard to kind of explain. They might be a little weird to kind of think about because normal people don't think about it. Consequential damages basically are damages that you suffer as a consequence of the breach that on the surface might not seem real obvious. In law school, how it's taught basically is there's a case called Hardesty is what I learned it in. But the basic idea, if you can imagine, is like, let's say that you are shipping something, via UPS or the mail, the U.S. Postal Service, and you pay, $10 to ship this thing, but this thing that you're shipping actually is not just worth $10. It might be worth millions of dollars because it's computer code, because it's, some research paper, because it's a patent or something. And, the value, basically is that, okay, this patent, if it arrives in time, this software code, if it arrives intact, that code or that patent is going to be worth millions of dollars. And if UPS or the Postal Service loses it, what are they basically in for? Are they responsible for all the money that you would have made from this software, from this patent? Or are they just responsible for, the $10 or $15 or whatever it is that they basically charged you to ship this thing? So I guess the consequential damages part basically would be like, is it kind of natural, foreseeable, I guess, that this item that UPS is shipping for you really is worth millions or billions of dollars? Yeah. So hopefully that kind of made sense. Consequential damages, you can Google it. It's not terribly involved, despite how I've explained it. But that might be one type of damage also. If you are in a situation where the other guy has breached, you might have covering costs related to your mitigation effort. Let's say that might be there also. That might be a component of your damage also. A really good example of that, I think, would be if you're a landlord and your tenant basically breaches, his or her lease. Let's say that they lose their job and they have to move out. All of a sudden, I guess, like even though you have a contract, if you have to suddenly advertise for a new tenant, there might be some incidental, like advertising sort of expenses, background check expenses, things like that. Whatever expenses are associated with moving a new tenant into a place. Those types of costs, incidental costs, maybe that's something you can recover also. So those are basically the 5 types of questions that I think would be really helpful for you if you have a breach of contract situation. It'd be helpful if you knew the answers to those. So to summarize again, to kind of recap, number 1, is the agreement or the contract in question, is it oral or is it written? And the reason that's important is because it's easier to prove a written document versus a oral agreement that people might have differing recollections on. Number 2 is, depending on whether or not it's oral or written, do you have the written document in question? Do you have witnesses or proof of some kind that an oral agreement actually existed? So basically, what proof do you have of this agreement, regardless of the form? Number 3 is, have you complied with all the different requirements, obligations that you have under this contract, or is your performance excused in some way? And the reason why that's important is because it's something where, in order to sue for breach of contract, you have to prove that you've done everything that you are supposed to first. Not a lot of people know that, actually. I couldn't tell you why, but you have to prove that you've complied first, or your performance, your compliance is excused. Number 4 is, what was the other guy to the contract, the breaching party? What were they supposed to do for you? That basically helps you determine damages. That helps you determine the scope of your case, etc. It actually just is more of a psychological thing to help you organize your case better. And lastly, number 5 is, what are your damages under this breach of contract situation? What are your expectation damages? What are your consequential damages? What are your incidental damages in terms of covering costs and so forth? So hopefully all that made sense. Again, breach of contract is something that is actually quite common, but it's something where, I don't know, I guess people don't really organize their case that well. So the thing is, hopefully by thinking of these 5 questions, by coming up with answers to them, hopefully they will help you organize your case better. You approach it in a more rational way. You're more prepared. And if you are more prepared, ideally that helps you get a lawyer faster, and it helps you, kind of get out of your situation sooner rather than later. So anyway, hopefully all that helped. Go ahead and watch this video again, share, comment, like, subscribe, all that stuff. And I will talk to you guys next time. Thanks.